The countdown to a total legal collapse has reached zero. In a Washington, D.C. federal courtroom, the air didn't just grow thin, it shattered. We are just talking about a bad day in court. We are witnessing the literal evaporation of two high-profile legal careers in real time. Federal marshals are on standby. The bar associations are already drafting the paperwork. Within 90 seconds of sheer, unadulterated defiance, attorneys Blackburn and Walsh didn't just lose a motion. They may have lost their right to practice law forever. This is the Verdict Watch USA, and today we are dissecting the career suicide that has sent shockwaves from the Department of Justice to the gates of Mar-a-Lago. Judge Martinez did not just issue a ruling, he issued a death warrant for their professional reputations. And the most shocking twist? Donald Trump himself is reportedly already using the word malpractice. The internal implosion has begun.
Visualize the scene. The mahogany-paneled walls of the E. Barrett Prettyman Federal Courthouse usually echo with the measured tones of constitutional debate. But today, the silence was glacial. Judge Martinez sat motionless, his eyes fixed on Blackburn with a piercing intensity that could freeze water. When Walsh rose to object, not with a legal basis, but with a political diatribe, the atmosphere shifted from professional to combustible. The judge's tone wasn't loud, it was sharp, like a scalpel. He warned them once, then twice. By the third time, the color drained from Walsh's face. He knew.
Counselor, you are not in a campaign rally. You are in a court of law, Martinez whispered, a sound more terrifying than a shout. When the order to eject came, it wasn't a request. It was an eviction. As federal marshals approached the defense table, the heavy chairs scraped against the floor, a sound like grinding teeth. Blackburn and Walsh were let out, not as advocates, but as disciplinary offenders. To understand the gravity of this, we must look at the foundations of our republic. Under Title 18, U.S. Code, Section 401, a federal judge has the inherent power to punish contempt of its authority. This isn't just a slap on the wrist. This is the nuclear option of the judiciary. We are looking at a direct violation of the American Bar Association Model Rules of Professional Conduct, specifically Rule 3.5, which prohibits conduct intended to disrupt a tribunal. By turning a federal courtroom into a theater for political grievances, Blackburn and Walsh have crossed the Rubicon. Historically, we look back at United States v. Nixon. The Supreme Court made it clear, no one is above the law, including the president's defenders. When a lawyer ceases to be an officer of the court and becomes a co-conspirator in chaos, the system must purge them to survive. This isn't just about one case. It's about the integrity of the third branch of government. The reaction from the legal community has been swift and merciless. Politico is reporting that the Office of Disciplinary Counsel has already opened an expedited inquiry. Legal titan Lawrence Tribe told MSNBC earlier today, "This isn't just bad lawyering. It's a full-scale assault on the judicial process. These attorneys didn't just fail their client. They betrayed their oaths." Over at CNN, analyst Ellie Onig pointed out the extraordinary contempt proceedings now looming. The consensus among the elite legal circle is unanimous. Blackburn and Walsh are radioactive. Even within the Trump camp, the narrative is shifting. Sources suggest Trump is fuming, viewing this not as a heroic stand, but as a procedural disaster that gives him grounds for an ineffective assistance of counsel claim, essentially throwing his own lawyers under the bus to save himself. We are standing at a precipice. This unprecedented meltdown mirrors the dark days of Watergate, where the line between legal defense and criminal obstruction became blurred. If a former president's legal team can be ejected and disbarred for their conduct in open court, we are no longer in a standard news cycle. We are in a constitutional emergency. The existential stakes are clear. If the courts cannot maintain order, the rule of law becomes a suggestion. The ejection of Blackburn and Walsh is the first domino. As they face permanent disbarment, the question remains: who will be left to defend the former president when his own defenders have committed career suicide? The gavel has fallen, but the echoes are just beginning to tear through the fabric of American politics.